this segment as the Gauteng High Court on Wednesday ruled what the Basic Conditions of Employment Act provisions pertaining to maternity leave are unconstitutional and invalid. The court said that they violated the rights to equality and dignity guaranteed by sections 9 and 10 of the Constitution. The court suspended the declaration of invalidity for a period of 2 years for Parliament to review and revise the provisions of the Act. An interim order was placed to grant leave to all parents, including fathers, the option to share 4 months of consecutive leave. Let's get some sense now on what this really means and its impact with Labour lawyer Patrick Deale. A very good morning to you. Thank you so much for your time. Maternity leave placed under the spotlight here. What does this judgment mean for parents who were unfairly discriminated against?
Good morning, and to your viewers. It means that the benefit of time off for new parents in various types of parents in various categories, in other words, natural birth, surrogate birth, and adoptive birth, all will have equal rights. That's the first essential one. And the second one is that the periods of time allocated to each parent in those various settings is distributed equally between fathers and mothers. The original problem with the existing problem, which hopefully will be cured or should be cured in the next 2 years when the law gets changed, is that there's a discrimination between mothers and fathers on the one hand, but also between amongst different sets of parents in the adoptive and surrogate area. So the idea is to bring the provisions of the Basic Conditions of Employment Act in line with 2 vital sections of the Constitution. The Section 9 deals with equality of persons, no matter who they are, and not to discriminate amongst people on any basis, sex, gender, religion, whatever. But also, secondly, that there's a clause, one-liner in Clause 10 of the Constitution that says that everyone has got the right to dignity. So that's essentially what this has addressed. And insofar as the first element is concerned, the distinction between mother and father, the underlying problem was that mothers get a birth mother, as they describe them, the biological mother, gets 4 months, or is entitled to 4 months unpaid maternity leave, but the father, the biological father, is only entitled to 10 days parental leave, both of which are unpaid. And that is considered to be unequal. And based on an underlying thesis or philosophy, if you like, that is in conflict with the Constitution, because what it assumes is that the mother is the primary caregiver and that the father, the biological father, is an ancillary one. And that's why he's only entitled to 10 days, but the mother is entitled to 4 months. And that's discriminatory on the one hand, but also it offends the dignity of the mother and the father if they want to have an egalitarian kind of relationship to share it equally, the nurturing of their children. So that is the underlying principle that was out of kilter with the Constitution in having different sets of arrangements and benefits for biological mothers, or birth mothers as they call them, and biological fathers. So the idea is that they get equally, the father then now also gets 4 months, and they can agree between them to share it. That, I'll take the first 2 months, you take the second 2 months, whatever. And that will be time off from work if they're both employed.
Is this the same arrangement for gender-neutral parents who adopt children?
Yes, it would be. It doesn't make any distinction between that, because if you're an adoptive parent, whether you're same-sex or different sex doesn't matter. As long as you're an adoptive parent and you've gone through the legal process of adopting, and you have a recognized relationship, even if it's for both. So it applies to both, effectively, if you're an adoptive parent. The rule is slightly suggested, or the suggested change to that in addition to being entitled to leave, is that the leave period is slightly shorter, but and it only applies to children of adoptive children who are younger than 2 years. So that's how that would apply in that setting.
Judge Roland Sutherland suspended the declaration of invalidity for 2 years to give Parliament time to cure the defects. What will that process entail?
Well, it involves the legislative process. It goes back to the drawing board, as it were. The legislators, the lawmakers, the law writers have to sit around and design the bill to accommodate this change that Judge Sutherland has proposed, or has ordered them to do that, actually, so that they put the draft bill together, and then it goes through the normal checks and balances within, and then it's open to public publication for comment, and then it goes through the various houses of Parliament in the normal way for passing of legislation. It's got to go past both, essentially, houses of Parliament. It's got to be approved by Cabinet and then assented to or signed off by the President. And all of that takes a long time. And all sorts of people need to be consulted, business, labour, individuals, interest groups, civic groups, etc. So that takes a long time to do all that. And I think Judge Sutherland has reckoned that about 2 years should be enough to get through all of that to end up with a product that reflects what his order has in mind.
So with the ruling now having to be confirmed by the Constitutional Court, what muscle or leeway does that give the Minister of Labour to exercise? Is there grounds for an appeal, should that be the route that the department will take?
They can appeal because it involves a change to the Constitution. Well, it involves a constitutional issue, not a change of the Constitution. It involves a constitutional issue in an existing piece of subordinate or lower form of legislation that has to be corrected to align with the Constitution. And so the Minister and the other parties involved in defending or trying to stop these changes can appeal to the Constitutional Court. But the Constitutional Court must then determine whether or not it is a constitutional issue, and I think it is a constitutional issue. But then I think on the face of it, determine whether there's some merit in taking it through all the way to the Constitution. And if I can just say, the judge gave short shrift to the respondents, the Minister of Labour and the other parties. There was an employers' organisation and others involved in this. They said there's no substance in these arguments or these defences that they put up. And I think so. Whether there's evidence or a case on the face of it to warrant going to the Constitutional Court, it might not pass muster before they even get into the court. It might be stopped at that point. But I think time will tell, and we'll have to see how that unfolds. What
impact do you imagine for the employer now, who now needs to put this into effect? What could we see as a ripple effect?
Well, it involved more organisation by the employer, more organising of time off to allow, essentially all of the new categories of leave that are being entitled and periods of leave that have been will be afforded to the various categories of parents. So it'll mean more time off for more employees over a period of time. It probably won't involve direct pay because they don't have to be paid while they're off. Those individuals can claim from the UIF. There's a special provision existing in the UIF for women or birth mothers on maternity leave to claim UIF benefits, and also for fathers to claim as well. And so there is that benefit there. And so the UIF itself will also have to make some changes in how it's going to spread the pot amongst more people claiming from the UIF. So employers will be faced with more time off, and for fathers and the other two adoptive or other two categories of parents, or for longer periods of time for the surrogates and for the adoptive parents. and to make a plan on how to replace that, but not necessarily for pay. That might come at a cost, of course, but that's essentially what it will mean. And they would need to align their contracts of employment, their policies and procedures, obviously to align with what this is. So new employees who are coming on board will have to have these provisions put into their contracts of employment, so it is clear that their rights are secured to be in line with this order.
Yeah, very well. Thank you so much for that very detailed insight. That was Labour lawyer and mediator Patrick Deale of Deale Attorneys, speaking there to the High Court judgment's findings on parts of the Basic Conditions of Employment Act as unconstitutional, ruling that both parents are entitled to 4 months leave. Let's take you now to